All right. Court of Appeal and for the 6th District of the State of Florida is now in session. The Honorable Chief Justice White, Judge presiding. All persons having business before the court draw near to this session and you will be heard. May God save the United States of America, the state of Florida, and the honorable court. Please be seated.
All right, good morning. Welcome to this session of oral argument of the 6th District Court of Appeal. As Marshall Crawford stated, thank you, Marshall Crawford. I am Judge Keith White. I have the honor of serving as the presiding judge for today's session. Serving with me today on my right is Judge Jared E. Smith, and on my left is Judge Joshua A. Mines. I do want to remind everyone that this session of oral argument is being recorded, audio and video. Just if you weren't already aware of one, you make you aware of that. And also, if everyone in the courtroom, please silence your phones during the oral argument, as well as any other electronic devices that might create a noise or a vibration. All right, our first case today is the Agency for Healthcare Administration. The Armando R. Pius, GAL et al. Case 23-1391. Are the attorneys for both parties ready to proceed?
Yes, Your Honor.
All right. All right, counsel. Oh, how much time would you like for rebuttal?
I'll reserve 5 minutes.
All right, very well. You may proceed.
Good morning. May it please the court. Alexander R. Bowler on behalf of the Agency for Healthcare Administration, or AHCA. KT made a substantial settlement recovery from parties liable for his injuries. AHCA paid for his medical care for those injuries and is entitled to be repaid from his settlement with those liable parties. A decade ago, in 2013, the Florida legislature prescribed an administrative hearing as the, quote, exclusive method for challenging the amount payable to AHCA. This procedure complied with the U.S. Supreme Court's decision in Alborn and Was, those decisions which limited the amount repayable to a state Medicaid program. KT initially pursued this administrative hearing, but after the hearing was held and before a final order was entered, he voluntarily dismissed his petition. Shopping for another forum, KT went to the circuit court that had heard his lawsuit against the liable parties, a suit to which AHCA was not a party. Because the Florida legislature made an administrative hearing the, quote, exclusive method for challenging the amount payable to AHCA, the circuit court does not have subject matter jurisdiction to reduce the amount payable to AHCA. This court should reverse the order on appeal and direct that KT's motion be dismissed for lack of subject matter jurisdiction.
Counsel, what do you say to the argument in their brief that there's really multiple sets of rights that can vest here, right? You have the right in the settlement, which vested when the settlement occurred. Obviously, you couldn't recover, your client couldn't recover something from the settlement until the settlement occurred, and they couldn't challenge your right to recover it. You also just have in 2009, the injured person took money, and they took money on the assumption that if it was ever, that money went in their pocket or it reduced the liability that they had. It removed one of their medical bills. And they did that with the understanding that if anything was recovered from third parties in the future, they'd have a right to a judicial determination as to how much should be recovered. So give me your best argument, your best response to that there were multiple rights that vest here. Your rights may have vested at the time of settlement, but they had rights that vested in 2009.
Sure. Well, they had no right to a determination of what was recovered for medical expenses until something was recovered for medical expenses.
Yeah, but they had a right to the money in their pocket, didn't they? Like they had money, they had a liability in the form of medical bill. Medicaid paid that liability. Liability went away. So in their, personal human being balance sheet, they had whatever the amount of that bill was, went away, and that was done. That bill no longer existed. They accepted that money on certain terms. And one of those terms was, if I ever recover anything and the state wants to come after me to get reimbursed, I'm going to get to be in front of a judge, and the judge is going to decide what the appropriate amount of that recovery is.
Sure. I think there are two ways to look at it. Either this is not retroactive application of a statute, which is what we believe. We believe that the statute in force at the time of settlement is what should control. But if this court were to decide that the 2009 date is the operative date, a change in forum, a change in jurisdiction is not a substantive change to the statute and may be applied retroactively.
All right, so it seems like you're conceding the point. Yes, something vested, but you don't think this is substantive, because there's two issues here. When did it vest? And then if it did vest, is this a substantive change? But it sounds like to me you're agreeing that something did vest, they had a vested right in 2009, but it's okay to change that, change the terms in which they accept the money because this is procedural and not substantive.
We don't agree that they had a vested right to contest the Medicaid lien in 2009.
But did they have a vested right in the money in their pocket?
Yes, and ACCA is not trying to take the money in their pocket in 2009. ACCA's lien is only against their recovery from liable parties, which did not occur in 2009.
Counsel, your opposing counsel cites associated industries in its brief, and argue very strenuously that it controls us. I assume you disagree. If you do, why?
Very much so. The reliance on associated industries takes one sentence out of context. If you read the entire case, it's something like 15 pages, where the Florida Supreme Court analyzes a new amendment to section 409.910 that happened in 1994. That amendment gave the Agency for Healthcare Administration a new and special right to go directly after tortfeasors. This was the tobacco litigation back in the 90s. The Supreme Court analyzed that new and special right to go after tortfeasors for constitutional issues, amongst other things, because it eliminated certain defenses that are traditional defenses. Out of context, the Florida Supreme Court states at one point that it's important to clarify when a cause of action accrues. It's talking about the cause of action that is ACCA's right to go after a tortfeasor directly, not a Medicaid recipient's cause of action to challenge the lien.
So when you say go against the tortfeasor directly, in this particular case, you're saying this statute that was construed in associated industries would allow your client to directly proceed against the same medical professionals that the plaintiffs below were seeking relief from.
ACCA would have been able to. That provision, by the way, the 1994 provision, was since repealed. The parts of it that weren't struck down by the Florida Supreme Court were repealed. And if I may quote from the Florida Supreme Court, after the modifications made in 1994, there can be no doubt that the act is intended to create an independent cause of action to which traditional affirmative defenses do not apply. That's at page 1249 of Associated Industries.
What about international paper, counsel? I looked at international paper and it seems to be pretty bare bones. It didn't really give much of an explanation for why the right to go to court is substantive, but in that 2 sentences or 2 or 3 sentences, it does seem to say it. So I agree there's not a lot of nuance to the opinion, but seems to say is that the right to go to court is substantive rather than procedural, doesn't it?
I think it.
We can't not follow a Supreme Court opinion just because it's not well written.
The first DCA and the third DCA have also addressed these issues much more recently, and I believe it was the third DCA. It explained that a change in venue or a change in jurisdiction, including the first DCA was one that moved from a judicial court to the Office of Compensation Claims.
International paper?
I don't believe they do directly.
Yeah, so The Florida Supreme Court case, first DCA case, we have to go to the Florida Supreme Court, right?
Yes.
Address international paper.
I think it's, as you said, very vague. And
Is vagueness a ground on which we can decline to follow a Florida Supreme Court case? I'll tell you, I didn't think it was a well-written opinion. It was like a 3-sentence holding. It didn't explain why, right? There's all kinds of reasons to say it was not a good opinion. That doesn't mean we don't have to follow it, does it? Maybe they need to overturn it, but we can't do that.
right, Your Honor. I'm not sure I have a better response for you.
What is your position as far as what is the holding of international paper? And former Justice Lawson and Pedroza v. State reminding us what a holding of the case is. And that's propositions on the decisional past that are actually decided based on the facts of the case that lead to the judgment. So what's the holding in international paper?
I'm sorry, I don't have that, in front of me. I think what you might be getting at is,
I think he wants you to make the case that statement is dicta.
I think what you might be getting at is that it's statement is dicta. And I think the first DCA and the third DCA's opinions are much more persuasive. Obviously, as a sister DCA, they're not binding on this court, but they follow a line of many cases that say that a change in jurisdiction, a change in venue, are not substantive changes in the law and are procedural.
Did you cite any cases in your brief by the Florida Supreme Court that states that jurisdictional statutes, if they are amended or repealed, they go into effect immediately because it goes to subject matter jurisdiction? Did you cite any Florida Supreme Court cases, DCA cases that stand for that proposition?
I believe the city of Lakeland. Yeah, the Florida Supreme Court in the city of Lakeland versus Cantanella, as well as Alamo Rental Car versus Mancusi, explaining procedural or remedial statutes are to be applied retrospectively and are to be applied to pending cases.
Well, if it was an issue of the statute being procedural, wouldn't that mean that cases that had already been filed, you have to get rid of them and say, go to DOA? Even cases that were the settlement and everything occurred prior to the enactment of the statute, like, litigation takes a long time. If there was a settlement that occurred in 2012 and there was a lawsuit over it, right? You concerned you concede prior to 2013 have the right to go to court, right? So if it's procedural, applies to pending cases, wouldn't that mean if there was a case pending on, I think it took effect July 1st, 2013. So if there was a case pending June 30th from a settlement that already happened, if it was procedural, wouldn't that mean you have to dismiss all those cases and send them to DOA?
Yes, Your Honor. We don't have any more of those. My client did not do that. That was not our position at the time, but that does not affect what this court should rule and hold, that only DOA has subject matter jurisdiction, either under the theory that it settled post 2013 and the law in force at that time requires that a Medicaid recipient go to DOA, or under a theory that even those that settled pre-2013, it's only a procedural change, a jurisdictional change, a venue change, not a substantive change in rights.
Are you relying on Suarez for that?
No, because Suarez Suarez states that something that's settled after 2013 goes to DOA. And I think that case is very persuasive. I think it addresses the issues properly, and the court below should have followed it. But even if it were, even if a case settled pre-2013, I believe it should still go to DOA.
All right, so case is settled 1995, longest litigation ever, still going on, July 1st, 2013. Your client files a motion to dismiss, no subject matter jurisdiction, you got to redo this 17 years of litigation. That's the right result.
17 years of
You told me cases pending as of the time of the act and statute should have all been kicked in favor of DOA due to lack of subject matter jurisdiction. That would mean no matter how far back the accident actually happened, or when the word settlement actually happened, or how long the litigation's been going on, July 1st, 2013, court loses subject matter jurisdiction and everybody's all those cases have to be dismissed. So you're telling me you've got a case settled 10 years before, accidents even farther before that, you've got years of litigation, clock strikes midnight, July 1st, 2013, all those cases had to be dismissed?
Yes, Your Honor, I'm not aware of.
So subject matter jurisdiction is one of the bases to vacate judgments that are already entered. Are all those final judgments invalid?
No, Your Honor, not after they're final.
So subject matter jurisdiction is one of the bases on which you can attack a final judgment after it's been entered. That's one of the limited bases, right? For instance, if you try to domesticate a judgment, right, that was entered somewhere, if you say the court lacks subject matter jurisdiction, or say you defaulted, right? So if you default in a case, normally you don't have defenses, but one of the defenses you can raise even years later is the court lacks subject matter jurisdiction. That is a basis to vacate final judgments already entered. I don't know if you knew that when you made the argument, because it puts you in a difficult position. All the final judgments entered in these cases that to which your client was a party before, that occurred after July 1st, 2013, but for cases before, are all those final judgments invalid and subject to being vacated? If that's what it would mean, if your argument, that's what it would mean if your argument is correct. If it's a subject matter jurisdiction issue and the court lost subject matter jurisdiction on July 1st, 2013, and every final judgment entered after that can be vacated.
All of those liens have been paid. There's no controversy remaining. I would imagine a case where subject matter jurisdiction changes, after the fact and the parties are done, would not be something that they could challenge. I realize what you're saying. I don't think it's either practicable or possible for such a late attack.
All right, counsel.
I see that.
I'll give you some more time since you were responding to Judge Mize's question. Thank you.
Thank you.
Good morning, may it please the court.
Morning.
Kara Link on behalf of the appellee. Nothing could be more substantive than a party's constitutional right of access to the courts. Article 1, Section 21.
Counsel, let me stop you right there.
Yes, Your Honor.
Did Judge Egan rule on the constitutional issue you just mentioned, access to court?
No, he did not, but we did reference it in our brief, referenced that it was a vested right. And Judge Mize, you talked about vested rights. There's no dispute in this record that my client's vested right occurred, as did ACCA's vested right in 2009. The statute is abundantly clear repeatedly. It's replete with when the lien vests, it's automatic. ACCA gets, and we're talking about the pre-2013, all the way up to, I think it's 2021, 22, maybe today. ACCA has a vested right. It's automatic subrogation, automatic assignment, automatic lien. The lien attaches automatically when a recipient first receives treatment for which the agency pays. It is perfected
Is that
automatically.
Associated Industries that you're quoting?
I'm quoting directly from 409.910 in the old version and the new version. So that vested right
I'm
of
sorry,
the
what was that statute again?
the statute, the Medicaid Third Party Lien Act, 409.910. It's subsection 6 in both the old statute, which applies to.
And that was
this appeal.
Associated Industries dealt with
Absolutely.
subsection 6.
It did. And I don't disagree that Associated Industries did involve that subsection involving tortfeasors and the right of ACA to sue tortfeasors directly. But you cannot strip away the statement by the Florida Supreme Court of when the cause of action accrues. The lien is perfected.
Counsel, we can't strip it away if it's
Yeah.
dicta.
Well, okay, well, that's the other case that I think you were talking about. I'm talking about Associated Industries, in that Associated Industries looked at, when does ACA's lien perfect? When does it vest? It vests in 2009 pursuant to the clear and plain language of the statute. The statute repeatedly says when the patient first receives treatment and Medicaid's paying for it.
But counsel, that was said with the facts of talking about the agency's lien against the third party
Tortfeasors, absolutely correct. I would then also turn to the Florida Supreme Court, Justice Overton's decision back over 50 years, 1976. Judge White, you asked the question, what was
Is that
the,
international paper you're referring to?
it is, yes, Your Honor. Thank
So,
you.
Address this point. I see, obviously, I made your point about international paper, so I see it.
Yes,
Multiple DCAs. I wasn't in those cases. I assume they looked at international paper,
right.
and multiple DCAs since then, without addressing it, albeit, have found that changing the forum is not a substantive issue. So do those courts just, and I understand we're bound by the Florida Supreme Court, even if another DCA, makes a mistake and not recognizing that.
Right.
but
Right.
Did they just overlook international paper? Because it's happened a couple of times by different DCAs, and nobody, doesn't seem that, opinions, I didn't see any that addressed it. Did they?
I didn't either, Your Honor. When you asked that question, I didn't either. And I'm thinking about Suarez. I don't know. I know in Suarez, they looked very narrowly at the date the lawsuit was filed. So I don't know if it was overlooked, but I would submit to this court, as I think you've indicated, regardless of how the opinion is written, it's controlling and binding on this court. Judge White, you asked the question of whether it was dicta or whether it was the holding in the court in that opinion. There are two parts of that opinion.
Which
that-
opinion are we talking about?
We're talking about international paper,
Okay.
the one that's 50 years old. The first holding is, the court looked at, it was a,
You're not suggesting 50 years is old, is it?
no, I'm not. I hope not. I'm definitely hoping not. But the first holding in that opinion is when the legislature amended Chapter 403, it eliminated the right of the defendant to require judicial determination. The amendment restricts a right previously held and is substantive, not procedural. We declined to give retroactive application to the amendment. The second holding in that opinion, Your Honor, goes to the constitutionality of the table of fish values. It was a really interesting opinion, actually, but fish values, and they held that the fish table values authorized by this statute and issue are proper and relevant, and it goes on, not applicable here. But the point is, the first sentence and the first holding of that two-part 1976 Florida Supreme Court opinion controls what we do here today. And it makes sense that the first treatment and the payment by Medicaid is when that right vests. It's perfected. It's an automatic vesting.
Counsel, let's go back to international paper. I agree with my colleague, Judge Mize, that it is a very interesting case. But in that case, isn't that distinguishable from this case on several fronts? First of all, the statute that was in effect, my recollection was, first of all, the state had an ability to seek damages against someone who violated the statute.
Right.
And they had two remedies. At the time, they could go into an administrative agency and get some administrative piece of paper that was worth, in my estimation, absolutely nothing. It was not enforceable like a court judgment unless they went to a court and had a de novo hearing, and then and only then would it be damages. So what the legislature changed was to allow the agency, correct,
Right.
to then immediately get something that was enforceable as a court judgment for damages without the involvement. I mean, that, of course, fits the legion of cases that say you can't impose a new penalty
right,
on someone after the fact because the fish kill
right.
had occurred prior to the change in the law. Isn't that very different than what we have here?
It could be. The other problem with the international paper case is that the statute didn't become effective until a year after the fish kill, but it was in effect at the date of the administrative hearing. So you do have a myriad, of different facts there. In this case, you have a statute that the legislature enacted in 2013. And I think Justice Antonin Scalia and Brian would agree. When you look at the 2013 version of this statute, it says this act shall take effect July 1, 2013. The analysis is over. There is zero legislative intent to retroactively apply the statute, and you have to look at the plain words of the
Well, that
statute.
depends on what the triggering event, right?
Absolutely.
Did the triggering event occur before or after July 1st, 2013? Can you address the contingent aspect of the rights? I agree. In 2009, your client, I think on the injured party, got some money in the form of one of her bills being paid. And She
Right.
accepted that money.
Right, it's a property right that vests.
Correct. Her right to challenge that money, though, was contingent on her recovering something.
Right,
So I
but
think, they've cited cases in their brief, and it looked correct to me that, if a right is contingent, it doesn't vest until the contingency is fulfilled.
right,
And here, your ability to challenge their recovery, their reduction of the lien was contingent on you not recovering the full amount of their lien, right? It was contingent on there not being the full amount of money to pay the lien.
right. But it's
That didn't happen until 2021.
correct. Well, the record's not, there is no record as to when it actually happened. And that's another
Right.
issue that,
So
that we,
I did not understand that portion of your brief. And
okay,
here's why. We are allowed, and trial court is allowed to look at the facts as we find them. You don't need a date of the settlement to establish that it happened after 2013.
right,
The record clearly establishes litigation happened after 2013. And it's of course true that you can't have the settlement comes after litigation.
right. I think,
So we know that we know the settlement happened after July 1st, 2013. We don't have to pin down the exact date to know when it happened.
fair enough, Your Honor, fair enough. To get back to your question, there were multiple rights that vested, though, as you indicated earlier. I agree wholeheartedly. And if you're going to say that my client's property rights and money in the pocket, the US Supreme Court WAS decision is contingent.
I'm sorry, the US Supreme, what decision?
WAS, WOS, WAS. The ACA lien is the triggering event, the ACA lien, and you have to, the statute, because the statute is so abundantly clear that it automatically vests the subrogation, the assignment, the lien
may vest, but
itself.
Your client's ability to challenge the lien is wholly dependent on a settlement being recovered and that settlement being less than the full amount.
But,
right? You
but,
don't know,
right,
like, as of the time your client accepted the money, if somebody asked you, are you gonna have a right to challenge the amount of the lien? You would have no idea, because you have no idea if you're gonna recover anything, and you have no idea if the recovery is gonna be less than the full amount of the lien. You could not give a yes or no as of 2009 as to whether you're gonna have a right to challenge that, challenge that reduction recovery. Could you?
I would not know. I would not know. But what I do know is that I have the right, and it's a vested right, to accept or reject the Medicaid money. If I knew that I was going to be
Where's
relegated.
that in the record?
Well, it's in the record, I have the right as the Medicaid recipient. If I know that it's going to be judicial or administrative, I know I have access to the courts. I'm going back to the substantive right.
Yes,
That's
Do you
the,
know that at the time you accept the bill? In other words, your client, presumably before the injury occurred, was already enrolled in Medicaid.
I don't know that, Your Honor. I can't say. I mean, I know that in 2009,
Well, they had to be enrolled in Medicaid before they accepted medical services, right?
at the time I will say at the time they received the first treatment that Medicaid paid for, they're enrolled because Medicaid paid.
So what I'm.
I don't
what I'm
know how
saying is,
far earlier.
Once your client was enrolled in Medicaid, you
Right.
know if they had the ability to not use Medicaid for a specific bill and to say, I want to pay this cash. Like, for instance, I know there's
think
the
you-
restrictions in Medicare, like if
Yeah.
a person is enrolled in Medicare.
Right,
They can't go into a doctor and say, I want to pay the doctor
Right.
is legally prohibited from
prohibited.
charging them more than Medicare rates.
Right.
They cannot make the decision on a case by case basis whether to pay a bill. So
I think
do-
the
do we
point,
know- Do we know that your client had the ability to decline to use Medicaid to pay this bill?
I don't know that there's nothing in the record with regard to that whatsoever, because these arguments weren't fleshed out below, which is part of the issue that I raised in the brief about lack of preservation, has nothing to do with the 2021. It's really about the arguments the interesting arguments, the constitutional arguments, the substantive right of access arguments that we're talking about today. So that wasn't fleshed out in my petition to,
In your experience, when courts have a way to decide something narrowly on facts versus go to the broad constitutional issue, which route do they typically take?
it depends. Depends on, I think, Judge Mize, if you were on the circuit court, I don't know, it just depends. It really does depend on the parties, the counsel and the judge. In this particular instance, this judge did look at whether there was a right that vested and determined which statute should apply, right? Because the court looked at whether it had jurisdiction or whether it should be in DOA, whether it should be in an administrative hearing. And the judge here looked at the Florida Supreme Court case, Associated
Let's go back
Industries.
to this 2009, I'm still, I apologize, it is early in the morning, I guess. Maybe the coffee's not kicking in. So what is the right exactly in 2009? What was that vested right? You say the right to the money, what money? There's no settlement at that point. And at that point, there's not even any alleged malpractice. This is,
Well, there's
this is at the time of treatment.
Right, the time of
Let's-
treatment.
Let's say it occurred right then and there.
Right.
There you have a malpractice claim, but you have no
Right.
settlement.
There are two vested rights. And I think the clearest vested right, Your Honor, is in 409.910, when the agency pays in 2009 for Medicare or Medicaid treatment, that right of lien, and it's a cause of action, it's a lien. It vests
Is it your
immediately.
client's lien?
No, it's ACA's lien.
Okay.
And so 2009, and it's important because the Florida legislature and all the variations of changing this act never changes that. It's to the protection of ACA.
But counsel,
So the
what
dollar
is-
one is
counsel,
liened.
what is your client's vested right? You would, well, let's make sure
Yes,
I'm understanding. Your argument is that we can't apply this statute because it affects your client's vested right. You're not saying that we can't apply it if we find it affects the state's, the agency's vested rights, are you?
I'm saying that the 2013 version that removes my right of access to the courts cannot be applied retroactively. My right of access to the courts, my client's right of access to the courts is substantive. That's a substantive change.
But counsel, that begs the question, when did your client's right of access to adjudicate this claim in whatever form it was adjudicated in arise?
The-
And I think what Judge White is getting to is you didn't have a right to challenge anything until you had a settlement. And you didn't have a settlement until at least 2021.
The lien is, I would say that my client's right of access occurs when their lien vests. Their lien vests, it's
Oh,
perfected and
Why does your client's right of access, like what right does your client gain from them having a lien? You don't have a right to challenge the lien yet unless you've got a settlement. What right does them, like if somebody records a lien on my house, that doesn't
Right.
give me any rights, gives me some obligations.
Right,
gives me some
rights and
hassle.
duties.
What right does a lien against your client give your client?
The statute allows ACA to file a lawsuit, and institute a proceeding. They don't
Not
have,
against your client.
yes, actually, it does.
At the time of treatment.
As soon as the lien it's in the statute, I will see if I can find it right here, but it's in the original statute, and I think it's in the 2013 one as well. But they have the right to institute an independent action. It doesn't have to
Against
be,
a third party.
no,
not your
no,
client.
against, I believe it's against my client as well, Your
So
Honor.
let me get this straight. You believe.
They don't
this-
have to, but they can. So
Isn't that, is
So,
that?
wait, hold on.
isn't
So,
there a provision?
hold on. So the you're saying that at the time of treatment. So your client gets treatment. Your client is on Medicaid because of your client's financial condition.
correct.
A payment gets made by the agency to the doctor. And then you're saying at that time, even though your client has no money at all, and in fact relied on Medicaid to even get the treatment, can immediately sue your client for the money that it just paid. That makes no sense whatsoever.
Yeah, no, I believe it says in the statute, they can file an independent action.
Against
or
a
they
third
can-
party.
Okay, oh, it could be, then that might be the version that we're talking about. Or it can file a lien or some motion or something in this action. And that's the vested right. It occurs, I mean, they don't have to wait until settlement. The statute, nowhere in the statute does it say their lien starts or commences.
The provision
on
we're talking about
settlement
here
date.
is that was changed to, make Doe the exclusive forum.
Right,
I don't think that provision applies to any actions against your client. I think it only applies to actions to recover money from a settlement. I don't think that, at least this provision we're talking about, I don't recall that provision. I look at it again.
okay,
If there is an action against your client, then I don't recall this provision having anything to do with that. This provision seems to pertain solely to the state's ability to go after settlement money to recover its lien.
well, if you're going after settlement money, that is after my client's
Yes, but the
property
point-
right,
Correct.
right?
But that doesn't arise 100%, but
Okay.
that doesn't arise until there's a settlement.
Counsel, if I may, so under your theory that you're presenting to the court, obviously we're reading in the record here, November 2009 was when the treatment began.
Absolutely,
So if the treatment, let's say the treatment began May 2013, and then continues until, because we don't know when it stopped, right?
Right,
And the order
correct.
doesn't say it could have gone well past 2013, probably did.
right.
So under your theory, after any treatment after 2013, we should treat differently than treatment prior to 2013?
No, I'm not saying that. And so thank you for the question so that I could clarify. Perhaps I misspoke. The statute says at the time when the patient recipient first receives treatment. So that's the vested right of ACA on its lien. And that's when the cause of action accrues. And that's why we look at that statute, which is a pre-2013, it's the 2009.
So let's just take that to the furthest extreme.
Yes,
If your client got $50 worth of treatment in May 2013 and $1 million worth of treatment after July 1, 2013,
right.
you're saying doesn't matter that the legislature has changed the law and now requires DOA to be the one to be the decider. Still, because of that $50 worth of treatment that was provided prior to the statute change, it's a vested right and the legislature can't touch it. That would be your
Yes.
position?
It is my position, and it's because the statute is so clear that that vested right occurs when the recipient first receives medical treatment. If the legislature wanted it to be a moving target or subsequent, they could have written that. And when they did write in 2013, they said this applies. Effective date is July 1, 2013. So in looking at that effective date provision, and knowing that their statute clearly says there are vested rights that are attached, perfected, it uses the word automatically
When you say
perfected.
vested rights, are you referring to anything other than Oscar's lien?
Primarily ACA's lien, yes,
Okay.
primarily
So
ACA's
the
lien.
argument that vested rights accrue is based solely on the fact that they have a lien.
They do, and that's, and
I'm
it's,
saying, I'm not disputing that they do. I'm saying, is
Right.
there any other basis other than that for saying your client has vested rights?
well, I think that Your Honor pointed out that there is a vested right, that my client has, a vested right, money in the pocket. But I think the argument has been consistently that the statute is clear. Their lien attaches in 2009 when my client first received payment. It isn't a moving target vested date. It's attached, it's perfected, and that's why the pre-2013 statute must hold precedence, must apply, and my client lost a substantive right or would lose a substantive right if this court reversed the trial court and said otherwise, because my client would lose the right of access to the courts. And I think you circle right back to both Florida Supreme Court decisions, understandably, that Associated Industries addressed the tortfeasor independent action. It still has a sentence in it about the substantive right of access to the courts, and international paper is still good law. Even though it has two holdings in it, I would submit to the court. The first holding is that that you cannot apply a statute that changes and removes the court access or the judicial access. We ask that this court affirm the trial court's ruling below. Thank you. Unless you have any other questions, I think I have 1 minute left.
Any other questions? That's fine.
Yeah.
All right, thank you.
Thank you very much.
Counsel, I'm looking at Suarez decision. I see one of the lawyers listed was a lawyer named Alexander Bowler. Why was international paper not brought up?
Your Honor, I was brought in on that case after briefing was done. There was no oral argument. The attorney before me got a new job, so I was not involved except to get my name on it. So I do not know. However, I don't think international paper is important for that case because the issue was the law in force at the time of settlement. So that there was no need to do, any retroactive application of a statute. I'd like to bring up the access to courts issue, which counsel for the appellee raised. Under the amended statute 409.910 subsection 17D, a Medicaid recipient has a right to appeal to the First District Court of Appeal. And therefore, the Medicaid recipient is not stripped of his or her rights to the courts.
Well, they have to go first, not sixth.
There are many issues. I know the 6th DCA is new, and it'd be cool to have a case here. But there are other.
Are there any cases that indicate that for those litigants that were in the 9th, 10th, and 20th Circuit on January 1, their vested rights were destroyed by moving from the 5th or the 2nd DCA to this court?
I'm not aware of any.
What about when the legislature changed the statute for appeals to go from, instead of county to circuit court, going to the District Court of Appeal? Any cases you're aware of that violated substantive rights?
No, Your Honor. And
do you believe that subject matter jurisdiction of a court is inherently part of the legislative power that they can give and take away as they see fit?
Constitutionally, yes, that they can alter the jurisdiction of the courts, and they can remove jurisdiction from one court and give it to another. And because there is access to in Article 5 court under the Florida Constitution, there is access to the courts.
Does the access to the court constitutional provision, does that even apply to a statutory cause of action?
I'm afraid I'm unaware of that, Your Honor.
Well, what really wasn't fleshed out below.
Let me ask you this, how are you, I'm sure you'd like to win any way you could, but if you had your choice, and there's two ways to decide this case. One, we say it's not substantive. One, we say it doesn't, substantive or not, the right to invest until after the statute was enacted, basically when the settlement occurred. Which one are you urging? Which route are you urging us to take?
I would urge this court to follow Suarez and say that the statute enforced at the time of settlement is the statute that applies. And the Medicaid recipient had no right to challenge the lien before the settlement existed. However, there is a third option, and I'm not suggesting you do it.
Let me ask you to address your opposing counsel and argues that the record's not clear enough for us to make a determination. If the date of the settlement, if we find that this change can't immediately go into effect, which we've argued, the parties have argued already at length, and we appreciate that. But if we disagree that it can go into effect immediately, no matter what, we have to determine this vesting date. What would, if we're not persuaded by the argument that it vested in 2009, but it vests at the time of settlement, which is what you're arguing, where would you point me to in the record that date was established?
Well, I think we're lucky here because KT was a minor. And so the settlement was approved by the lower court. And so I believe it's page 50 of the record is the approval of the settlement by the lower court for the minor. And that was in 2022.
So your argument is that's the vesting date upon approval by the trial court of the tentative settlement reached by the parties that required judicial approval.
Yes, Your Honor, because if the lower court did not approve it, there would be no settlement. And Judge Mize, with my last minute, there is a third option. KT went to DOA and pursued an administrative remedy and voluntarily dismissed his petition. By doing so, he has failed to exhaust his administrative remedies and cannot instead seek the circuit court. We would ask this court to reverse the order on appeal and enter an order requiring, and require that the lower court in order to dismiss KT's motion. Thank you.
Thank you. Thanks to both counsels for your preparation and argument. We appreciate it. Okay, what's going to use it now? All right, apologies for my lack of technical efficiency. This is the first time that I've actually presided and have to learn how to use this timer. All right, the next case before us is Sulzer v. American Integrity Insurance Company, 23-391. Our counsel for both parties ready to proceed? All right, counsel, please proceed.
May it please the court, Paul Feltman on behalf of the appellant Sulzer. We're here today on a case that I believe has been been argued at least twice before this court. I know that I saw an oral argument in Hughes that took place. I think that was April 6th. And basically it's what I would say is a straightforward issue, but apparently it's not turning out to be that way. We have the issue of the statute, which was passed into effect on July 21st, 2021 by the legislature. And we know some basic rules of statutory construction. And that is first, that the legislature, if it wants for something to apply retroactively, must explicitly for that to happen. Second, that the inclusion of an effective date abuts the retroactive application of a statute. Third, that a statute in effect at the time a contract is executed is the one that controls. And in this matter, those are rights that are vested within the policy. And that would include the right to the insured here, the insured, to be able to recover attorney's fees. They paid a premium for that. And the insurance companies took that into consideration when it was issued. And then the last rule, statutory construction is a presumption against retroactive application. Those are the legal principles before the court as it relates to the notice issue in the statute. And I would like
Counsel, if I may jump in, just how
Yes,
much
Judge.
time for rebuttal? Sorry, were you saying?
5 minutes. Thank you.
No, I apologize, counsel.
No, I apologize for.
So, counsel, if I may jump right in, and I'm sure you're familiar with the Devon case.
Yes, I am.
Okay. So in the Devon case, Justice LaVarga says, in speaking about section 627-7015, which is not the statute in question here, but still insurance related. He says, thus, section 627.7015, as amended in 2005, cannot be characterized as simply procedural or remedial, but was clearly substantive. Therefore, the presumption against retroactive application of the substantive amendments applies in this case. So, as I read that, the first question we have to ask is it a purely remedial or procedural statute? And if so, then we don't worry about the legislative intent. It doesn't have to be clearly expressed because it's going to get applied retroactively. We don't have the presumption against retroactivity. So my question to you is, what makes this statute substantive?
Okay, what makes it substantive is section 3 requires a notice of intent to sue. Section 5 will get a dismissal if the notice has not been given. And section 8 says that there will be no attorney's fees that would include pre-suit fees, which we know under the case law are recoverable, and attorney's fees are substantive under all of the case law. And so the notice and the attorney's fee provisions are inextricably intertwined.
Why?
Because, as I just said, the issues of the giving of the notice and then the dismissal, if it's not given, and again, we have a policy and a loss that occurred prior to the effective date. Effective date rebuts it being applied retroactively. It ties back into the issue of attorney's fees. You would get pre-suit fees normally prior to the enactment of the statute. So that affects it and makes it substantive. And Your Honor, just so it's clear, during the Hughes oral argument, counsel for Universal in that case sought to argue that there would be a recovery for attorney's fees pre-suit in order to decouple, that was before the Cole case, to decouple the attorney's fees issue from the notice issue. But you cannot do that here. The statute is looked at holistically because the Supreme Court says in Menendez was followed in Devon, and Devon says this applies to property insurance contracts. Very clearly, it was a unanimous court. Justices Kennedy and Polston were also there. And it was a unanimous court that said that the analysis in Menendez will apply. And so the issue.
Devon.
Correct.
But neither Devon nor Menendez dealt with this statute.
No, it did not, Your Honor. But those are the controlling issues in terms of the construction of this statute. And
But how can either Devon or Menendez, the holding of either of those cases, be a holding that applies to this statute when that statute wasn't even enacted?
well, I mean, that's the nature of case law and statutory construction when looking at remedial versus substantive remedial procedure statutes or substantive statutes. And in this case, you have a statute that is procedural and also substantive, and they cannot be parsed out because they're inextricably intertwined.
But where's that holding that you just said? Where I know what Menendez did. I agree with you. Menendez did exactly what you were talking about in the context of PIP. Justice Parente, again, propositions actually decided on the decisional path based on the facts of the case lead to the judgment. She said all of these things lead us to conclude the statute is substantive. But all of those things in Menendez, actually none of those things in Menendez are here, are they?
Well, it's a different statute, but we're dealing with the principle of law that has been applied to several different statutes. It's the two-part test. And in this case, and then going back to Devon, they applied that two-part test in this case. In Devon as it relates to property insurance.
Counsel, I just want to make sure, because my initial question was, what makes this, in your opinion, substantive? Obviously, I'm sure that's your position here, and I know it is per your brief. I wanted to make sure I got a complete answer. So you mentioned the fact that there's a notice of intent to sue and no attorney's fees. Had you completed your answer? I know we've been throwing a lot of questions at you. Is that your complete answer to the question of what makes this statute substantive?
Yes, because the notice and the attorney's fees issues cannot be separated, because at the time that the policy was issued, the insureds had paid for a premium that allowed them to be able to recover fees. It was taken into account by the insurance companies. Pre-suit fees were recoverable under Florida case law. I've cited it extensively within the briefs. And so what that would do is, if you were to dismiss the case, then there's this issue of, yes, you've affected the substantive right that existed as part of the policy. You're changing the policy terms if you're not allowing for pre-suit recovery of attorney's fees.
So let me ask you this, counsel, then, and maybe this is an easy question to answer. It's one of
hope
the
so.
easiest ones I ask. Let's say we disagree with you on the severability position, that this particular attorney's fees provision could be severed, that we could look at it as not raised in this case, that we could say, as many prior cases have done, sever out the portion that we feel is substantive. Look at Menendez as distinguishable because it's a PIP case, and they were grappling with, as set out in Menendez, the very first statement of the court is, this is a special statute. This is a statute that requires expedient, no fault resolution of claims, which is the exact, definitely not at all what we're dealing with here, which is just your normal homeowner residential insurance claims. So let's say we can somehow distinguish Menendez. We are able to parse out the attorney's fees and say, that's not for the court, and we would have no problem with severing that out insofar as we consider procedural versus substantive. At that point in time, would you agree then that this then flips into the remedial statute category and can be retroactively applied?
Well, no, because Devin says that this applies to property insurance contracts. Devin, the issue was, I think it was a notice of mediation, if I'm correct.
Appraisal. I think
Right, it was
yeah.
appraisal, and then there was whether the notice of mediation was given.
But the loss of the right in Devon was the right to an appraisal. That was
Correct.
That was the substantive change in Devon.
Correct.
It was a true, I mean, I think we would all agree that you take away somebody's right to an appraisal, that's a substantive change. I don't think that anybody's disputing that, but that you're not losing a right like that here. So my question would be, if this court were to disagree with you on the severability argument, then how is just having to file a notice of intent to sue, how is that not procedural and remedial? Would you agree that if we're able to sever out the attorney's fees, that then the statute does become remedial?
Well, if you were able to do that, but you're not, because it's
Okay.
not.
So, but I mean, and I appreciate your candor to the court. So you're saying that even though you completely disagree and say you can't do that, Judge, but if somehow we found a way to do it, you would say, I wouldn't have any legs to stand on this. I would have to concede it's a remedial statute. Is that correct?
If they had decided to draft it as to just this issue of notice, and there are cases that I've cited within my brief that discuss the fact that just because a statute is remedial does not mean that it can be applied retroactively. But then again, we get back to the substantive issue, which you're asking me about. And I don't think there's any way, because you go to 3 on the notice and 5 in the dismissal, and then 8, the fees are taken.
I know you're having a hard time directly answering my question. But
No,
I
the
mean,
question is,
but
if
the
they had
bottom line
passed,
is-
I'm sorry, you're on.
Yeah, I mean, bottom line is though, you would say that if disagreeable is, you would say you're doing it the wrong way, court. But if somehow we did sever out the attorney's fees provision, or say that's not before the court here today, everything else in that category within the remedial will have to be applied retroactively.
If they had drafted it that way, yes. One of the things that I would like to bring to the court's attention, which I think is where some of the issues are going to be going, depending on whether or not the courts apply the bright line rule that has been set down for many years in the state as it relates to retroactive application of statutes. And I read the legal principles at the beginning there. And this is a fact. The Cole case has been used, and this is record in the state of Florida. So I'm referring to a record in the state of Florida as to this. In the case, it's PRUSIS versus Universal. It's in Palm Beach Circuit Court. It's case number 22 CA 1034, and that was on the Honorable James Nutt. They were on the eve of trial, and the judges dismissed the case. So you have hundreds or thousands of these cases that are now pending, and this issue of the attorney's fees when they accrued is not going to go away, and there's certainly.
But it's not before us now, is it?
It's going to, well, I think that any decision that's made will take into account what the impacts will be going forward. And certainly that has to be one of those.
Well, what I mean is, in this case, and obviously I wasn't on the panel in Cole, but reading the opinion, I was on the panel in Hughes. In all of these cases, this issue of attorney's fees that you are as part of your argument, and I understand that argument, but that's really not before us, is it? Because all the judge has done in this case, my understanding, correct me if I'm wrong, if I'm asking this question, because I very well could have missed something. Right? My understanding is that the trial judge dismissed your client's action without prejudice to file a new action with no ruling whatsoever as to whether your client is or is not entitled to attorney's fees, and no ruling whatsoever as to whether the defendant below is or is not entitled to.
In other words, when you send the notice and refile the suit and get your attorney's fees, then would that not be the case?
If the court, and I think that counsel for the plaintiff in the Hughes case said to some extent what I'm saying now, which is if the court will put that into in its opinion that is the case, that the attorney's fees, the pre-suit attorney's fees that were accrued in the one that was dismissed, and then this going forward would be at issue and recoverable. Then if it's addressed, which I don't believe it was in Cole, that may be something that would allow for
Well, there might
that
be
separation.
I mean, there's two categories of attorney's fees. There's pre-suit attorney's fees,
Right.
and then there's fees incurred in a suit that, assuming you had an obligation to bring notice, should have been brought, at least not before you brought the notice. So you can see how pre-suit attorney's fees would be incurred no matter what, right? Because that's pre-suit and pre-notice. Whereas fees during the suit that would not have been incurred but for the lack of compliance with the notice provision. Those fees would not have been incurred had you complied with the notice provision. So you can see a distinction between the two buckets of fees. In other words, like when you don't comply with the notice provision, you're not supposed to bring a suit, right? Like, and if you bring a suit you're not supposed to bring, you're not always supposed to recover your attorney's fees.
I understand what you're saying, Your Honor. However, that doesn't take into account the vested right of the ability to recover fees in the policy that existed, and the notice is impacting that vested substantive right that was in the policy. That the right to fees is in a policy when it is signed, and that's been the law.
What I'm saying is, assuming somebody complies with the notice provision, and they have, in the church, if I have to claim whatever, they have to proceed to sue, they're still going to get all their fees under the policy, they just have to comply with the notice provision first.
Right, and then that's going to be a series of obligations that were not under the terms of the policy that are being imposed upon them.
Basically, some courts have rules that in order to recover your attorney's fees, you have to disclose your fees each month. All right, the Northern District of Florida has that rule. If you're in the Northern District of Florida and you want to recover fees, every month you got to send in your bills. That wouldn't be a contract. Would that be substantive? Because if you don't do it, you don't get your fees.
No,
Not even
those
contract.
are
Contract
rules.
is your right to recover fees, right?
Those are rules of court. No, and I would now that you've raised the district court cases, I have cited the majority of them, save one, in the northern, middle, and southern have all found that the statute is to be applied and reviewed holistically, and they have found that in the case of this statute that it should not be applied retroactively. One other just quick thing so I can save a little bit of time.
Well, counsel, you're already into your rebuttal time, but I'll give you some extra time since you were responding to Judge Mize' question.
Okay, I did want to just make this point, so if opposing counsel wants to respond to it.
Well, hold on. Did he complete his answer to your question?
Go ahead.
There was a very simple way, if these companies, the insurers really wanted to nip this in the bud up front, that they thought there was an issue, and it's just to issue some discovery, and they could get everything they want immediately at that time without having to go through all of this process. If they really wanted to evaluate these claims in the second instance, because they already went through it once, or my client, a complete denial of coverage. So with that, I'll reserve it for a little bit.
And if I may,
Go ahead.
so a question, and I don't know if you got your laptop and you can look this up, but in my research of the remedial versus substantive, which I think really is a big one on this case. Obviously, to me, it's the pinnacle issue. I went back and dug a little deeper in the Florida Supreme Court history on what they considered remedial versus substantive. And I found a case from the first DCA, Cunningham versus State Plant Board of Florida. Interesting case, has been cited numerous times by the Florida Supreme Court for its proposition related to what is a remedial statute. I think it's, for all I can say, it's still good law. Cert was denied on that case. In that case, the challenge was to the fact that they passed this statute for orange tree growers to have to, and if you're familiar with the case, stop me at any point in time, but they passed a statute saying if you've got orange trees and the government comes in and rips those orange trees out because they think they're diseased or damaged, here's the process you have to go through. You have to file a claim with the state plant board. You can't just go directly to court, and then that state plant board, they're going to look at your claim. You have to file a written claim with them. They have to look at it. They'll send you an offer. If you don't like the offer, then you can ask for a hearing. If you don't like the result of the hearing, then you can go to circuit court. There were some other provisions in the statute that were considered to be substantive, limits on how much could be paid for the trees. The statute went to the Florida Supreme Court. Florida Supreme Court knocked out the provisions that were substantive. Any of the dollar caps on the trees. They said that's substantive. That was a substantive right. As for the procedure, the fact that they required them to first file their cases with the state plant board in writing, get an offer, ask for a hearing, not like the hearing, and then sue, that was all considered to be procedural. That was remedial, upheld. And so I'm giving you this in advance because on rebuttal, I'm probably gonna throw this out to the other side, but I'm gonna ask you, how do you distinguish that case from our case here, which seems to be much, much lower than that? And certainly no one argued to the Supreme Court, hey, or the first DCA, hey, we got our case dismissed. What about our attorney's fees? This is really substantive because now what's going to happen, all the attorney's fees we had to pay out. I mean, that wasn't even a thought. They didn't follow the procedure. Their case got dismissed. Had they followed it. So some food for thought, counsel. I will give you a chance to respond to that when you come back up.
I appreciate that. I remember that part of our state's history, and I don't remember how much of that went into the takings case law or not. But I'm not.
You'll have an opportunity to respond.
Thank you.
All right, thank you.
And counsel, if you want to write down that the site is 112 Southern 2nd 905. That's the kind of office. 905 112 Southern 2nd 905.
Good morning, may it please the court. I'm Ashley Paxton, here with my co-counsel Tom Hunker on behalf of American Integrity Insurance. I just got stumped with the orange grower case, but I think I want to start by saying 627 and 70152 is not per se a retroactive statute. And I think that's where courts are getting misled at the beginning of the analysis, when you have a defendant moving to dismiss on the basis of plaintiff not filing, complying with the pre-suit notice requirement, and simply moving to dismiss on that basis, and then the plaintiff automatically
Counsel, I'm going to
coming
jump right
in.
in and just
Okay.
ask you what I think is going to be the toughest question we have to
Okay.
grapple with. And that is, how do we distinguish this case from Menendez?
Well, Menendez,
Speaks a lot to delays.
pardon, yeah.
Statute seems to involve some delay.
Which statute?
The statute at issue in our case and in Menendez.
Well, yeah, it does incorporate, but it doesn't incorporate a delay to what we've been reading as a vested right. And in Menendez, the right to the benefits had already vested by the time they gave their notice. They have 30 days. The insurer has 30 days to provide the benefit. And the statute in Menendez, the amendment, increased that time. So it added a provision to the contract that wasn't there. It says it's not 30 days, it's 37 days.
Doesn't this statute do something similar when it essentially gives the insurer a second bite at the apple, right? So insurer denies a claim, they get the notice of intent, they get a second chance to pay before getting sued. And they
Well-
get that extra time to decide on the claim. Looking at Menendez, and it says, we conclude that the 2001 amendment that permits the delayed payment from an insurer and postpones an insurer's ability to bring a suit for overdue benefits also to maybe independently presents a substantive change. And here, the insurance ability is postponed because they got to go through all these steps, right? That postpones their ability to bring suit. And the insurer gets to delay payment, right? Because the insurer could say, well, we're going to wait and see if I actually sue this. We're not going to pay the first claim, but we're going to wait and see who sues. And then if we get a notice of intent to sue, then we'll pay it. So they get a delay, just like in Menendez.
Well, the parties under the homeowners insurance policy, they have, the insurer has agreed to deny a claim or pay a claim or extend the time to investigate. In Menendez, the parties, the right to that payment has already
But isn't that form over substance,
happened.
right? The insurer here can deny the claim when they get the notice of intent to sue. Then they can investigate. I think they can, they can request 14 days to inspect. So they get a second chance to investigate that they wouldn't otherwise be entitled to, and then get a second chance to pay the claim. All right, so it seems to be form over substance to say, well, yes, but there they changed how the policy works. Bottom line, insurers get more time to pay. They get a second bite at the apple under the statute that they wouldn't have had otherwise.
So you have, say you're an insured and in this case, the insureds were denied coverage in January of 2021. And they filed their complaint in September. So they had, what is that, 7 months? They could have filed it as early as the day they were denied coverage, or they could have filed it right after. They could have gone to an attorney sometime after July 1st and said, we disagree with the
fact that
coverage.
one
attorney.
person delayed bringing their suit doesn't change how the statute works. Before, insurance company denies your claim, you'd sue. Now, under this statute, you've got to give them this notice. They have procedures they can go through where they give an automatic, an automatic period of time by which to reevaluate the claim, reinvestigate, and all that delays. That is by law now, a period of time they can wait to bring the payment without getting sued, isn't it? They can wait, they can
Mhm.
deny a claim or not pay a claim. They can wait to get that notice, take all that extra time, and they suffer no penalty for paying the claim later, right?
Or else they have to go into litigation. They have to pay for their own litigation, and then they have to pay for
Only
attorney's fees.
if they continue to deny the claim. My point is the delay, right? So before, insured makes a claim, they deny it, they get sued.
Mhm.
Now, insured makes a claim, they deny it. They get a second period where the insured has to send them this notice, and they can require, reinspection, they get a reinvestigation. They get a second chance, second period of time to evaluate. And the insured is delayed in suing until after that. I'm looking at Menendez and it says, pursuant to the 2001 version of the statute, an insurer has an additional period of time to meet its obligation under the statute. And an
Mhm.
action for a claim of benefits cannot be initiated until the additional time for payment is expired. Then it's thus, based on that, Supreme Court says thus, it substantially alters the right to pay. Here, before the insurer had a right to sue, now they don't, until they bring this notice, they bring the notice. After they bring the notice, the insurance company gets a period of time in
right.
which they cannot be sued to evaluate the claim and decide whether to pay it. Is that not an entire second process that didn't exist before?
I think the statute gives the insured a mechanism to hold a fire to the insurer and say, we are going to sue you, and you have 10 days to deny or grant coverage, or
Right.
else we're
Your
going.
position is the statute increases the insurance leverage over the insurance company? You think that's how the insurance?
I don't-
company uses it?
No, I don't think it increases their leverage, but I think that it speeds up the time during which the insurer has to make a decision about coverage without the court. So you're not worrying about an insurer disputing, going through all this litigation and having the insurer dispute whether there's coverage. The insurer is going to quickly, promptly make a determination of whether there's coverage before it has to go to court. And then the right to seek a determination of coverage where the parties are disagreeing is different from the right to benefits that vested the minute you gave notice to your PIP insurer. So between 0 days and 30 days in Menendez, the insurer is supposed to pay the insured. Here, you don't have the right to coverage until if the parties are disputing whether the damage was covered, until there is a determination of coverage. But the law already provides that the insurer is supposed to be diligent in its efforts
And
to.
now, if they're not diligent, instead of getting sued, they have this process to go through. Sort of like the process in Menendez.
Mhm. They do have a process, but I think they have notice that they have to go through the process from the minute the statute's enacted. It's not part of their contract with the insurer. So in Menendez, they have a contract with the insurer where they are entitled to get these benefits immediately upon providing notice, as long as they're being honest. In with 627, 70152, they have not contracted a procedure by which they're going to enforce their rights under their contract. So this statute that prescribes a mechanism for enforcement has nothing to do with what they're already entitled to. Their entitlement to a determination of coverage and to the insurer's performance, if the damage is covered, doesn't change.
Counsel, in the opening paragraphs of the Menendez opinion, the court first quotes the no fault statute and citing one of the Florida Supreme Court decisions from 2007, stating the no fault law is a comprehensive statutory scheme, the purpose of which is to provide for medical, surgical, funeral, and disability insurance benefits without regard to fault, and to require motor vehicle insurance securing such benefits. And then the court goes on with its own statement. This last observation is significant because any impediment to the right of the insured to recover in a swift and virtually automatic way has the potential for interfering with the PIP scheme's goal of being a reasonable alternative to common law tort principles. Would you say that distinguishment, I know you're going point by point with the two statutes, What about the distinguishment back to the PIP statute would you say it's different in nature than homeowners insurance?
Well, the PIP statute is you have people that are out of work. They're suffering from injuries. They don't have childcare. They need money immediately. And the statute aims to provide for their needs without all of the investigation of who's at fault and whether they are entitled to the benefits. So what the statute's trying to provide immediate relief to people who are injured, they're out of work, they have bills, they might have children, they need immediate health care. And the homeowner statute doesn't have the same, it doesn't implicate the same urgency that I think this PIP statute's trying to address in terms of people's immediate needs for funds.
So I mean, if you go through Menendez on the surface, they say the most problematic provisions in the statute that it imposes a penalty, implicates attorney's fees, grants an insurer additional time to pay benefits, delays insured right to institute cause of action. Many of those, frankly, are present in this statute. But what I'm looking at is should we treat this differently than a PIP statute?
Well, this statute doesn't change anything that's in the contract.
What
So,
about attorney's fees?
well, the attorney's fees, I think can be parsed out, but this.
What if they can't? I'll ask the flip side
Okay.
of Judge Smith's question.
And-
What if the holding of Menendez is, your opposing counsel argues, and that is we have to take this holistic approach? Would you agree that under the case law, attorney's fees is substantive? And so if you agree with that attorney's fees is substantive, do you agree that if we can't sever it, it failed?
Okay, I did a diagram of this when I was trying to write the brief. In the reply brief, the appellant writes that 627-428 is the substantive statute. That statute in 2018, when the parties entered into a contract, it does not mention 627-70152 because it wasn't in existence then. When 627-70152 came into existence, it references the attorney's statute, .428. If you are trying to focus solely on the substantive statute, which is 627-428, that statute in 2018 does not specify that damages are limited to anything besides what attorney's fees are limited to anything besides what may be afforded under the contract. The 2021 version of 627-428 specifically references 70152 and says damage or attorney's fees granted under this statute for homeowners insurance policies are limited to the prescribed table, and I don't think they use the word table, but what's prescribed in 627-70152. So I think you can read the two statute, the homeowners policy statute in harmony with 627-428 if you are allocating the substantive portion of 627-428 to 2018 when the contract was entered into between the parties. These are the expectations they had. And then once you get to the end of the case, insured is entitled to attorney's fees. They're not limited by that mostly procedural statute that determines the amount of attorney's fees based on how they complied with the pre-suit notice requirement, or how well they negotiated prior to the lawsuit. Does that make sense? Or,
So are you saying, is your argument that opposing counsel's argument about potential loss of attorney's fees, that's not going to happen? Or are you saying we don't have to address it today? Maybe I don't understand the argument.
I think that, well, the court told the fourth DCA opinion, they said we don't have to do it to address it today because it wasn't before the court. It wasn't before the court in this case. So I think you can safely say that it's not an issue yet, but if they were to prevail, I still think that you could apply 627-428 that was in effect at the time they entered into contract, and it wouldn't limit their attorney's fees for their not their failure. They still have to comply with the pre-notice requirement, but that part of the statute that demarcates the different levels of attorney's fees that the insured is entitled to wouldn't apply, so that limitation wouldn't come in.
So if we say we don't need to deal with the attorney's fees today, it's not for us, and we hold this as procedural because we're only looking at the notice provision, we're not looking at the attorney's fees. So we impose the notice provisions. What happens when a future panel has to deal with the attorney's fees issue and find it can't be severed? We do have to deal with it, it can't be severed, and the attorney's fees provision is substantive and it's inextricably intertwined with the notice provision.
Well, again, I think
We'd be saying everybody has to comply with the notice provision because it's procedural.
Mhm.
The later panel would be saying that it's substantive because even though it might have been procedural on its own, it's intertwined with the attorney's fees, and the attorney's fees are substantive. Can we really not deal with the attorney's fees and risk that happening, that interpanel conflict?
When you read, I think it's in the first part of Part 8, the statute reads, the attorney's fees that may be awarded under section 627.428 or the other statute will be allocated as follows. And then it refers back to the pre-notice negotiations and how closely they fell to what the final judgment was. If you just read that first part of Part 8, and it says, and you read pursuant to section 627.428, that is the substantive statute that you're looking at for the award of attorney's fees. So you look at the substantive statute that was effective when they entered into contract, and it didn't have that limitation pursuant to the pre-notice provision. The pre-notice provision still accomplishes the purpose of mitigating against too many lawsuits or unnecessary litigation, because you can't go farther than getting past the motion to dismiss for failure to go through the pre-notice procedure. But as far as the attorney's fees go, I think you can still harmonize the 2018, you can still use the 2018 substantive statute in harmony with this 2021 70152 that applies from the date of enactment going forward. So it applies starting July 1st. Anything that would ordinarily not fall under a version of 627.428 that precedes 2021 would fall under that part of that statute of 428. The substantive part, the substantive statute remains 627.428. And that's the one where you have to use the date that the parties entered into contract, because that's the provision that is where the entitlement to fees comes from.
Fine, my question. Yeah. All right, thank you, Counsel.
Okay, okay, thank you.
In addressing Menendez and going back to your question to me, Judge Smith. Menendez says that if a statute impairs a vested right, or fees, creates new obligations, which clearly the notice provisions do create new obligations on the insured. Or imposes a new penalty, which would be the dismissal or denial of fees.
Does a requirement to go to mediation, does that impose a new obligation?
Um,
Does that delay your client's recovery?
it could,
Judges do it all the time.
yeah, judges do, we know that we all have to go to mediation before we go to trial.
Does that affect your substantive rights of everybody, both sides?
I think that the court has determined that it hasn't. In this case, I want to just finish with the Menendez line, and I appreciate your question, Your Honor. There seems to be this idea that for some reason, the insureds, the property insureds, shouldn't have the right to get an immediate recovery in the same way that the insureds in the PIP actions should. And I don't think that that's really fair to this class of insureds in the state of Florida. And that notice provision does delay that ability to make that recovery. It seriously does.
Which
case
tells us to decide what's fair.
Well, what Menendez says is, does it create a new obligation or impose a new penalty?
And it does contain the word fair.
No, it doesn't, Your Honor. It doesn't. I'm speaking to you in layperson's terms. But what it does do, it does impose a new obligation, and it does impair a vested right, creates a new obligation, and imposes a new penalty.
Counsel, I
And-
mean,
and-
if you, the problem with that language is in a vacuum, in isolation, there could be no further procedural requirements ever in the state of Florida. They would all be considered substantive, because even filing a piece of paper with the court would be an obligation. That's why I had to look backwards to figure out remedial versus substantive. I think problem with just taking words out of Menendez, they sound great, but that what you just said illustrates my point, which is, Judge, if you create a new obligation, anything creates a new obligation, anything procedural is an obligation. It's a procedural obligation versus a substantive obligation. That's the distinction I think we have to be careful to make here is, are we talking procedural versus substantive obligations? But
I don't disagree, Your Honor, but what I would say is that the issue really then is, are we going to make these procedural obligations retroactive to apply to policies and losses that occurred prior to the enactment of the statute?
yes,
And
that's exactly the
Right.
issue. And counsel, if I may, my question would be going along with that. If you have a procedural requirement, let's say that procedural requirement is to file a civil cover sheet with your lawsuit. Okay, you don't comply with it and your case gets dismissed. You have lost a substantive right because you failed to follow the procedural rule. Does that then make that procedural rule substantive?
I don't believe that it would, Your Honor, but at the same time, that's not, and those aren't the facts of this case. Because
Well,
this is,
let me go to my step two on that same
oh,
question.
okay,
So we've got what we all agreed was just a remedial procedural requirement of a intent to file the notice that you've got to file with the Department of Insurance. And if you don't do that, then your case gets dismissed. What's the difference between your case being dismissed and your case is dismissed? And oh, by the way, you don't get attorney's fees on that dismissed case. How does that convert a procedural requirement into substantive simply because we tack on, you lost the substantive right of everything involving your lawsuit? Oh, and by the way, you can't get attorney's fees either. How is that any different than you just lost everything with your lawsuit because we just dismissed your case because you didn't follow the procedural
because
requirement?
Menendez would look at that, because you have the policy, as creating new obligations that were not there by the enactment of the statute. and it would impose the penalty of dismissal. It's something that was not there at the time of the enactment of the statute. So I understand what you're asking me and what you're telling me, but at the same time, this isn't, this is against the rule of retroactivity, which is very clear. And there are the cases, I believe I cited them in my brief, that just because a statute is remedial and maybe it would do something to, make something better, it's remedial. That's for the legislature to do. If they want it, they know how to do it. I filed some supplemental authority that showed just in a recent enactment that they knew exactly how to make something remedial if they want to make it remedial. And in this case, they certainly couldn't have done that, but they gave an effective date, and that effective date is what it controls. And I know that this case started in the second DCA. There were 3 PCAs, and I understand that those don't have a precedential value. Under the case law, the panels there and the judges there could have had a discussion about those cases. Those are 3 cert petitions which were denied, and all cited each one of them to Menendez, which is an indication of what the panel there was thinking, which obviously is not binding on this, but I'm not trying to imply that. I just wanted to raise that because from where the case came.
You find it persuasive.
I find it persuasive, as I find the district court cases persuasive, obviously not controlled.
If we rule for you, do we need to serve the conflict rule?
I guess that would be dependent
Yes,
upon
right.
it. Yes, it would. But I do know this, and for what it's worth, I know there are at least 2 other cases in the third, and one of them is being set sua sponte for oral argument. So this is going to be with all this for a period of time until it gets sorted out and works its way into Tallahassee.
Other than Cole, should have asked this in the beginning. I certainly didn't find anything. You haven't, neither you nor your opposing counsel brought. Other than Cole, is there any DCA that addressed this issue that you're aware of?
No, there are not. That's why and Cole wasn't out when I drafted my brief and relied upon the persuasive authority of the multiple district courts in the state, which had found it to be something that needs to be looked at holistically and not applied retroactively. So we'd ask that the court reverse the order on appeal and remand for further proceedings.
Counsel, did you have anything you wanted to add in relation to, because I didn't just throw the case out for no reason. When I read the Cunningham case, to me, it was a powerful impact on the way I viewed remedial versus substantive. I don't know if you had a chance to
I did
email your law clerk and
no,
ask them
that's I turned my phone off.
yeah, that's good.
And I don't have, that's a rule for me. I just don't have my
Fair
phone
enough.
on. I didn't
I
want to turn
wanted to
it
give you a
back on.
chance to respond to
I
it.
would start beeping and everything. I would like the opportunity to respond. I don't know if that's an opportunity the court could give to both parties to submit just a letter brief on the issue of Cunningham. If that's something that we're able to do, it would be appreciated, just because I don't have the ability to respond to your request of judgment.
Anything?
Thank you. And
All right.
my flights were canceled last night, so I got up at 4 to drive from Miami to come visit you today. It's my first time before the 6th TCA, and it's just been a pleasure to be here. I really,
Thanks to both counsel for your preparation
Thank
and your professionalism, your argument. We appreciate very much. Very sorry about.
no, thank you for giving us the extra time.
All right,
I really
thank
appreciate
you.
it. Thank you.
All right. You okay, going forward? Okay. Okay. All right, let's see. All right, and the last case set for today is Epic Management Consulting v. Texas Bank Financial et al. 23-1442. Counsel for the parties ready to proceed?
Yes, Your Honor.
All right, thank you. You may proceed.
Thank you. If I may reserve
Oh, yes,
5 minutes for rebuttal, please,
Thank
Your
you.
Honor.
to both my colleagues. You may proceed.
Thank you. May it please the court, Lauren Reynolds from the Winter-Weedle Law Firm on behalf of Epic Management Consulting, Inc. The court should reverse the final judgment of foreclosure entered in favor of the bank. That judgment permits the bank to foreclose its mortgage lien, which was terminated by operation of law prior to the filing of the bank's complaint. Anything other than reversal constitutes a revival of the mortgage, which is not permitted by statute and would be contrary to the intent of the Florida legislature. In fact,
Your brief, you cite a lot of cases, governing intervention outside of the context of a mortgage with a list of bids filed. All the cases I saw involving intervention after a list of indents have been, for a person who bought a piece of property after a list of indents have been filed, said one of two things: there should be no intervention at all, or if the court has discretion, the other bucket would be the court has discretion to allow intervention, but not for raising beneath the defenses. I get your argument about the statute of repose. That's a defense somebody has to raise. So the antecedent question is, did your client have a right to raise them? I could ask this question about 6 different cases. How do you distinguish your case from Ventures Trust, Whitburn, State Trust Realty, and the Trust Dima Investments and the Komarov? I didn't see any cases specific to these facts that go in your favor. And it seems like if we rule for your favor, we'd have to certify conflict with every DCA except the first.
I understand what you're getting at, Your Honor. But I think what's important to note is that none of those cases involve a lien that has been terminated by the statute of repose.
Well, hold on. That is completely beside the point. That's a defense. They don't involve that because they didn't get to the defenses issue. They didn't get into substantive defenses because the holding of the cases was the intervener doesn't have a right to raise substantive defenses. So it's a non sequitur to say, well, there's substantive defenses here. The issue is, does your client have a right to raise substantive defenses? And it seems to me every DCA except the first has to disagree that the first DCA case on it. Seems to me the second, third, fourth, fifth have all said no substantive defenses. That's the whole purpose of a list of indents. Notice, hey, you buy this property, you may be out of luck, right? That's what it is. So don't tell me about the defense. Tell me how you distinguish this case from those that say you don't get to assert defensive.
Well, Your Honor, it's difficult to separate the two. And so respectfully, I would say that the statute of repose, it's not just a defense. It actually cuts off the cause of action altogether. It says that it just doesn't even exist. And so the plaintiff doesn't even have a claim to sue on. And so, Your Honor, just to kind of segue.
In a case, say you were just the defendant in this case,
Mhm.
does the statute of repose have to be raised? Doesn't it permit that be pled, be raised and
Well,
asserted?
Your Honor, I think even if there were no defendants at all, let's say, the bank still has an obligation to prove its prima facie case, which it just can't do here because it doesn't actually have a cause of action at all. The statute says,
Straightforward question on straightforward answer. You statute of repose on affirmative defense that must be pled.
Your Honor, I think I don't know that it is. And I say that just because, like I said, the statute of repose, it terminates the cause of action altogether. Now,
Is there
Your
any
Honor,
case in the state of Florida you're aware of that's ever held statute of repose is not an affirmative defense that must be pled?
not that I'm aware of. So even if, as Your Honor is suggesting, even if it has to be pled as an affirmative defense, here, certainly we were allowed to intervene. The trial court determined that was appropriate, and we would submit that it was. And so even if, let's say, we're allowed to intervene, but we step into the shoes of a borrower who was deceased and his heirs who were defaulted, At the very least, at a bare minimum, we should have been permitted to raise failure to state a claim as a defense. Any defaulted party can raise that defense. And that can be raised in an answer, that can be raised as an affirmative defense, it can be raised in a motion, it can be raised at trial for the first
Sorry,
time.
what can be raised?
Failure to state a claim, Your
Okay.
Honor. That can be raised as a defense even by a defaulted party.
Did you look for cases that say statute of repose is not a form of defense? You don't have to plead?
I did not, Your Honor. That was not an argument. I did not. But again, Your Honor, our argument, our position here is that because of the statute of repose cuts off the cause of action altogether, it extinguishes the cause of action. And so if a plaintiff
When you say
can't-
extinguish, and I saw you sitting in the gallery, so you got the benefit of our discussion on subject matter jurisdiction. Are you saying that this statute of repose is a subject matter jurisdictional statute, and it says the courts of this state shall have no jurisdiction to enforce a lien past whatever the statute of repose the legislature says?
The statute doesn't use those words, certainly. But what it says is that the mortgage lien shall terminate after the expiration of 5 years of the maturity date, when that maturity date is evident on the face of the mortgage.
You gotta prove standing to establish cause of action, right?
Yes,
If you don't own the mortgage, right?
Yes.
If I sued somebody and said, I've got a mortgage on your house and I didn't own the mortgage, I wouldn't have a claim, right? Just by saying I have a mortgage when I don't, right?
that's right, Your Honor.
But if you default, you admit standing, don't you?
Absolutely. So if you have a default, certainly you admit all of the well-pled allegations of the complaint.
Including that we have a valid mortgage.
Well, no, Your Honor, that's a conclusion of law. Whether the mortgage is valid is a conclusion of law. That is not a fact that can be pled. That's not a fact that's admitted when there's a default entered.
What about forgery?
So, Your Honor, those are the distinction that I would draw here is that forgery is the type of inherently factual issue that arises between the borrower on the mortgage or note and the bank. And that's distinctly different than the legal issue of whether the lien exists at all. If there's no valid lien to foreclose, then the bank doesn't even get to come into court and file its case in the first place. And this,
But they do get to file even if their own agents commit a crime and sign purportedly for the borrower and then foreclose. They can move forward there, but they can't move forward on some arbitrary statute of limitations or statute of repose that doesn't involve criminal conduct, just they missed their deadline.
I see what I see where you're going, all right. It doesn't seem equitable that should be the case. And if there was truly a forgery, but I think
And of
what
course, foreclosure is
is
court of
inequitable.
equity has been for centuries.
Absolutely. And I think what you see in these purchaser pendente lite cases, of which admittedly there are many, but I think what you see in those cases are situations where you have these purchasers that, they buy these properties for pennies on the dollar. They come in and intervene typically years into the litigation. And then they raise all these factual defenses that they actually have no knowledge of because they weren't there when the note was signed. They weren't there when the payments were being made. They weren't there at any point, and they just try to delay the litigation as long as possible. But that's really not what we have going on here. Here, our client paid value for the property. The probate court found the property to be worth $160,000. Our deed reflects that we paid $175,000 for the property. We actually paid more than it was worth. The timing of this case is very unique in that when the notice of list pendens was recorded, it fell into the gap period between when a title search is run and closing occurs, right? That happens.
Risky business your client's in, right?
It is, and it happens in rare instances. I think it's unusual. And so we took without actual knowledge of the list pendens, but even still, even with constructive knowledge or actual knowledge of the list pendens, what that list pendens gives notice of is simply the fact that there's a lawsuit pending. And if you look at the lawsuit, you see that the mortgage is facially terminated. by application of the statute of repose. And as I mentioned, that statute says that after the expiration of 5 years from the maturity date, the lien shall terminate. There's no question there. There's no ambiguity there. The statute is very, very clear. It's very unambiguous, and it reflects the judgment of the Florida legislature, which was to terminate the mortgage lien. Now, the statute also provides that there is only one way, only one mechanism in order to extend the life of a mortgage lien. And that is through a recorded agreement signed by the borrower and signed by the lender prior to the time of the expiration of the lien. And I just want to quote for the court.
If we go back to our office, find cases that say statute of repose is an affirmative defense that must be pled, do you?
I don't think so, Your Honor, because we still should have been able to raise failure to state a claim as a
Hold on,
defense.
it's an affirmative defense. Your failure to state a claim means it's not affirmative defense, part of the claim. I'm telling you, if we go back to our offices on West Lawn, and there's a bunch of cases that say statute, because I asked you to look at the cases, you said no. I presume you don't know whether they're there or not. We go back to our offices and get on Westlaw, look up the statute of repose and affirmative defense, and there's a bunch of cases saying yes, it's an affirmative defense that must be pled. You lose.
I don't think so, Your Honor. Because I think there's a couple of different ways to get to the result that we think this court should reach. Now, if statute of repose is an affirmative defense that we need to raise, that's certainly one pathway. But I would submit another pathway would be to raise failure to state a claim, which can be raised at any time, even by
What's the
defaulted
failure to
party.
state- A statute of repose is something you admit by default, right? That would mean it's not part of stating the claim. If an affirmative defense by definition admits the claim and defends it, right? That's what affirmative defense means. It means you may
Right.
have succeeded on your claim, but I have a defense nonetheless, right?
That's
So
right.
if a statute of repose is an affirmative defense that must be pled, that means by definition, you can't raise it as a failure to state a claim. So what is taking out statute of repose, what is the failure to state a claim?
The failure to, well, I don't think they can be separated, Your Honor. I mean, the failure to state a claim is that there is no mortgage lien
Counsel, I
to,
just told you how they're separated. An affirmative defense by definition is something that admits a claim. It says, yes, you have a claim, but I have a defense. The definition of an affirmative defense, right? Failure to state a claim means you don't have a claim, right? That's
Right.
means you don't have a claim. Affirmative defense means you do. But I have a defense to it. So if we go back to our offices, and there's a bunch of cases that say statute of repose is an affirmative defense that you must raise, that must be pled or waived. That would mean it's not failure to state a claim, it's an affirmative defense, correct?
I think if what you're saying is that by stating failure to state a claim, that assertion cannot be linked to the statute of repose in any scenario.
If it's an affirmative defense, that would be the case. That's what affirmative
Okay.
defense means.
I follow now. I'm sorry, Your Honor. It took me a while to get there. If that's the case, and if the court also concludes that intervention should not have been permitted and we should never have been able to defend at all, then that's probably correct.
Okay.
But Your Honor, I would submit to this court that the statute of repose is not an affirmative defense.
I think there's a lot of cases saying that it is.
And counsel, let me ask you then, let's assume that we go back to our offices and we can't find the cases, and actually the cases say it's not an affirmative defense. It's an element of the cause of action that has to be alleged. But if there's a default entry, that legal result is all well-pled allegations in the complaint are admitted as true.
That's right.
And so how can someone in default then, not counting unliquidated damages, which clearly a defaulting party has a right to have a trial on that, either bench or jury, depending on the case. But how can you raise a motion make a motion for failure to state a cause of action when you're in default?
So, Your Honor, the case law is very clear that a defaulted party can still raise failure to state a claim. And that can be raised at by motion. It can be raised even at trial for the first time.
By an
And
intervener.
if an intervener steps, let's say that we were permitted to intervene, we step into the shoes of the heirs as the bank argued. And so they were defaulted, and so now we're defaulted too. The case law still suggests, even after a default is entered, the defaulted party can raise failure to state a claim as a defense.
And which cases are you relying?
I would refer your honor to the Bank of America versus Eastridge case out of the 5th DCA. And that case is actually, I think, pretty instructive here.
You say
Because-
East Ridge?
Eastridge,
Okay.
yes, your honor.
Thank you.
It's 253 Southern 3rd, 722.
Any
Um,
Florida Supreme Court case hold that someone in default can raise, they can make a motion for failure to state a cause of action without having the default set aside?
I did not cite to any, your honor. At the time that we filed the brief, we were in the 5th, and so I primarily cited to 5th DCA cases, which I recognize now are not binding on this court.
But a Florida Supreme Court will bind any DCA.
Absolutely.
That's why I was asking.
Absolutely.
Is there any Florida Supreme Court case that you're citing in your brief?
There is not. I'm not sure if there is one that we perhaps could have cited. But your honor, I would just point you back to that Eastridge case, because I think it's pretty instructive here. And in that case, the court found that it was it was an error to fail to consider, in that case, it was the bank's failure to state a claim defense, even after a default was entered. In that case, there was a dispute over title to the property. The plaintiffs had basically moved in and occupied the property, and they were suing for adverse possession. And they alleged that they had possession of the property for 4 years, and they alleged other elements of an adverse possession claim. The bank didn't respond timely, default was entered against it, and it stepped in and raised failure to state a claim as a defense. And the court said, no, I'm not considering that, you're defaulted here. It entered judgment in favor of the plaintiffs, but on appeal, the bank said, no, they didn't state a claim. They didn't actually state a claim because they only occupied the property for 4 years. The statute requires 7 years. And so I think that's pretty analogous to what's happening here. The bank doesn't even have a lien that it can enforce. The mortgage lien shall terminate after the expiration of the time set forth in the statute. And so if you don't have a lien to enforce, you can't come into court and enforce that lien.
But it sounds like, and now you're pressing my recollection, that Eastridge, on its face, the allegations of the complaint weren't well pled. That is, the burden on the plaintiff is to establish that they have been in adverse possession of the property the requisite number of years.
Right.
Sounds like on its face, that wasn't.
Well, I think that's actually really similar to what's happening here. The bank can allege that it has a mortgage, but if you can see on its face that maturity date, then by statute, there's no question it expired, it doesn't exist.
Where's the requirement, assuming that if we find Eastridge persuasive, where's the requirement of the bank to allege that they filed this within the statute proposed? Where is that an element of their cause of action that they have to allege?
Well, I'm not sure that it is. They have to allege, but the bank has to allege the existence of a valid mortgage lien. And they can't do that here. The mortgage lien doesn't exist anymore. And there's only one way to extend its life, which is to follow the procedures set forth in the statute. And this statute is very, very explicit. It confirms, and I just want to quote this for the court because I think this is so powerful. But the statute explicitly confirms that an extension of the life of a mortgage may only occur, quote, as provided in this law, and shall not be extended by any other agreement, non-residence, disability, part payment, operation of law, or any other method. So the only way to extend the life of that mortgage lien is to follow the procedures in the statute and to record a modification agreement signed by the borrower and the lender that extends the life of the lien. And that never happened here. That is undisputed. And so regardless of whether we've admitted the well-pled facts of the complaint, we don't admit conclusions of law. And there's only one conclusion of law that the court can reach, and that is that the mortgage lien terminated. And I see that I've used pretty much all of my time. So unless the court has any other questions, I'll reserve whatever I can for rebuttal. Thank you.
Thank you.
Good morning, Your Honors. May it please the court. counsel Charles Gufford, co-counsel Curtis Wilson on behalf of Texas Bank Financial. Your honors, obviously, I know we're going to be opening up to questions, but I think the main point is that even by me sitting at my desk, we were able to find case law that stands for the fact that the affirmative defense of statutory repose is just that, and it must be asserted. And the default cuts the parties off, as in this case, as in we have in Green Emerald Homes, which is a second DCA's Toucan Property Brothers versus Boney Mellon, which is also a 5th DCA case, and also in Ventures Trust, which I'm sure the judges have already looked at. Again, when a property is purchased during a pending foreclosure action in which a list pendants has been filed, the purchaser generally is not entitled to intervene. First of all, we still argue they shouldn't even been allowed to intervene in the case, your honors. Second,
Hold on. You
Yes.
didn't cross appeal that, did you?
I did not cross appeal that, your
All
honor.
right, so that's not an issue.
Understood,
Nothing
yes,
to
sir.
do about it?
Nothing we can do about it, right?
Okay.
I'm not gonna, but still, the fact is the court can look to that to see what happened. Again, but if we're gonna talk about the intervention itself, which was granted in limited fashion, it's just abuse of discretion, and the court in the lower tribunal did not abuse its discretion by limiting the party or limiting the intervener to not oppose or interject any new issue into the case. That's on point. That's in every case that we've cited in our brief to the justices or to the court president. I didn't know if the court, I can also go into the fact of the fair to state a cause of action if the court would like. Again, and we cited this in our brief, your honors. We only need to state in the complaint that we have an agreement. We provided a mortgage, we provided a note, we provided a modification. That's the first element. The second element is there a default. We pled a default. It was a default of November 1st, 2019. We pled acceleration, which is the third element of a foreclosure action. And we pled an amount due, which was we met all the burdens required to factually state an accurate cause of action before the court. That's why judgment was entered. That's why we were entitled to judgment as is, your honors.
What about the Eastridge case?
Well, that's the whole point. I agree with the court. The ruling is accurate in Eastridge, but that's the issue. Did we not state an accurate cause of action? And the cause of action under Black Point Assets versus Fannie Mae, which is cited at 227 3rd 566, only requires us to cite to those elements, which I just said to the court. That is it. Going into any further behind the mortgage.
In other words, in Eastridge, their facts that were admitted did not establish the cause of action. You're saying your facts did establish the cause of action.
That is correct, your honor.
So you agree with the holding in Eastridge, your argument is it doesn't apply here.
That is correct, your honor. The courts can also look to, your honor, which is a 5th DC case of Irvin v. Grogan Cole. That was another case that we cited to the facts that although our case involved a purchaser post list pendants, this involved a pre-suit litigation where the mortgage had extinguished, but there'd been payments by the borrower with the lender, and the court ruled under the 5th that because of those continued payments, it extended the statute of repose, extended the statute of limitations. And this is even considering the fact that they can even make those arguments, which we are not conceding that at all to the court. They have no right to do that. But the court can rely on that to make the finding that we actually properly stated a cause of action, because then in that case, the statute of limitations was extended because the borrower was continuing making payments under the expired mortgage, which in that case, the owners took subject to an expired or an allegedly expired mortgage based on the facts in that case. I understand I have 16 minutes, your honors. I just want to make sure I entertain any questions we have with this case. I don't want to bore the court with.
Well, what about the language of the statute, the opposing counsel? And it seems like the legislature spent an awful lot of time trying to cover every potential way that some mortgage beyond this time that they determined was appropriate would be barred.
Oh, I agree, your honor, but the fact is it's still an affirmative defense that must be pled. Statute of repose, statute of limitations. You don't get that start. We don't even get to that point to even consider it. The other issue is
Now, is that just the general, because I'm familiar with the general body of law and fresh my recollection, I may be forgetting it. Is there a case cited in your brief that holds that general principle to this statute of repose?
No,
This
sir.
Statute of repose must be pled or it's.
No, sir, it's not. But I think it's the general proposition And again, as sitting out, I was able to find the case law that supports it. So yes, Your Honor, it's not cited into my brief. However, you also have to look into the fact, as the court pointed out, it's a court of equity. And the facts stated in our complaint do establish that there were further payments past the date of maturity on the mortgage. There was a loan modification, although not of record, I agree. Again, extenuating circumstances that show that the validity of the mortgage still existed and that the parties are in a continued state of payment until the default.
Are those factual circumstances surrounding the application of the statute of repose one of the reasons why it's an affirmative defense?
I'm sorry, I'm not fully understanding the
Is
court's
the
question.
factual nature of the statute of repose one of the reasons that the case is hold is an affirmative defense?
Correct, Your Honor. Yes, sir.
Or is it an element of the claim?
That's correct, Your Honor. It's not an element claim. I apologize. Your Honor, I just want to make sure I focus on the right issues. I know there's 14 minutes. I want to take any more of the court's time on these if there's any other issues the court may have.
We'll ask this because I don't recall, and again, I apologize if I've overlooked this in briefs, but I don't recall seeing this. I mean, my experience, foreclosure proceedings usually have many defendants. Borrower was clearly in default. Was there any defendant that raised the statute of repose?
None, Your Honor. The only people who answer, I believe, are the clerk of courts, and there was another defendant. I can't recall their name, and they did not raise any defenses to the viability of the foreclosure or the ability of Texas Bank Financial to foreclose.
All right, thank you, counsel.
Thank you, Your Honors.
Thank you, Judge. So first of all, I'd like to point out that the statute, it's not a traditional statute of repose. This statute actually terminates the instrument altogether. It terminates the mortgage lien altogether. And so by the time the plaintiff comes into court, the lien on which it's trying to enforce simply no longer exists. It terminates altogether.
Counsel, do you cite any case where some other type of lien that has some expiration on it, that issue, that defense can be raised even though there's been a default at some later time? For example, what comes to mind is construction. They terminate after 1 year. Any case says that doesn't have to be raised, that's got to be alleged by the lienor, can't be waived,
So
distinguishes the cause of action as a matter of law.
yes, Your Honor. So if the court looks at the American Bankers case out of the second DCA, that involved this particular statute at issue, and I would urge the court to adopt the reasoning of that case.
I mean,
And
what, American Bankers?
American Bankers case.
Okay, that
Yes.
refreshed my recollection. All right,
Um,
but that was this statute, right?
It was, Your Honor. It was this particular statute, but so I guess my point is that there are other cases that have interpreted this statute as being as powerful as we're asking the court to interpret it to be today. And so in the American Bankers case out of the second and the Zlinkoff case out of the fourth, both of those cases are really factually analogous to what's happening here. And they, I think, are legally on all fours and legally correct in that they apply the very plain language of the statute. And those cases both found that a subsequent purchaser was able to take title to those properties free and clear of the bank's lien when it had terminated.
And American Bankers, like the defendant raised the statute of reposes, which is an affirmative defense.
Yes, they did, but that case goes on to explain the difference between a statute of repose and a statute of limitations. In the statute of repose, it cuts off it just terminates and extinguishes the cause of action altogether. And here, the statute goes even beyond that, and then it terminates the lien altogether. So how can you enforce a mortgage when the lien that it purports to represent just doesn't even exist anymore?
You can't bring any claim that's the statute of repose, and I get your point, this gets rid of the lien, as opposed to just the cause of action. But you can't bring any cause of action that doesn't exist. right? That's the distinction between statute of repose and statute of limitations, right?
Exactly.
Statute of repose means it doesn't matter if anybody learned about it, doesn't matter if anybody knew or how fair it is, the cause of action ceases to exist. As
Exactly.
for all causes of action, it's still an affirmative defense in all those cases. And in the case you cited, it was raised and pled in an affirmative defense.
Yes, that's true. It was, Your Honor. But because it cuts off the cause of action, our argument at least is that the plaintiff could never prove its prima facie case. Even with all the facts undisputed, it has no mortgage lien to enforce at all. Now, I'd like to go back to the intervention piece of this because I think it was you, Judge Mize, that pointed out that the court did allow us to intervene and entered an order on that. And the court determined that we were a party defendant to this lawsuit. And so that order has not been appealed. That finding has not been appealed.
But
So
well, counsel, let me ask you this. Would you say that you had an absolute right to intervene or was it permissive?
Your Honor, I think in this case, it was probably a permissive right to intervene.
I would agree. And so looking at the comments to rule 1.230, the first paragraph 3 states, in view of the aim of the rules to allow liberal joinder of parties and claims, the intervener should be permitted to counterclaim, cross-claim, and plead third parties, which sounds great until you read after the comma, which says, unless a denial of the right to do so is made a condition of allowing the intervention. Then the rule goes on to say, in imposing the comma, in imposing such a condition, the court should consider whether the intervener has an absolute right to intervene or only a permissive one. And they go to a few other factors, which include the stage of application for intervention, the nature of the claim, and other factors. They literally say and other factors. So looking at this case, which is permissive, and then looking at the two rulings of the court, one of which is, you're correct, in June 28, 2022, the court ruled that you were permitted to intervene, but specifically the court said a separate hearing shall be scheduled to determine Epic's right to file defenses or additional claims in response to plaintiff's foreclosure, which seems to fit right within the rule. And then later we have an order on July 11, 2022, where the court specifically stated that you were not permitted to, your motion to file an answer and raise affirmative defenses and counterclaim was denied by the court. So it seems that the court, although they allowed you in, they did what the rule permitted them to do, which is limit your appearance, which my understanding of this rule would be it's a damages case at that point. You're talking about damages, you don't get to raise the defenses that you're raising. So what would be your response to that?
Yes, Your Honor. So my response to that is that the trial court, you're right. I think it engaged in the correct kind of two-step analysis that the rule in the case law talks about. But what the case law also says is that once a court determines intervention should be permitted, then it's an abuse of discretion to then not allow the party to actually do anything, to actually defend or participate at all. And I would point.
Case you cite for that, it's not in the mortgage context, right? There's like.
That's right.
There's cases from every other DCA except the first saying absolutely the opposite of what you just said. That even some say you shouldn't have been allowed to intervene at all, and the ones that said intervene was permissible, all said you do, it's that the court cannot allow you to certain defensive.
Your Honor, so you're right. It's from outside the mortgage foreclosure context, but I don't think that makes that case completely wrongly decided or inapplicable here. And I would also.
The fact that there's a bunch of cases from within the mortgage context that say the opposite, make those cases inapplicable.
Well, so Your Honor, I'd like to point your attention, if I may, to the Green Emerald Homes case, which was cited by the bank. In that particular case, actually, it says a couple of things that I think are important and relevant here. One is that a purchaser pendente lite is stopped from challenging a facially valid mortgage. And I would argue that our mortgage here is not facially valid. It's facially invalid because of the statute of repose. Second, those pendente lite cases, they repeatedly state that the rule is general. It's a general rule so that the trial court can look at the facts and circumstances at issue and exercise its discretion, which is set forth in Rule 1.230 on intervention. And that's what the trial court's allowed to do. Then I'd also point, Your Honor, back to Green Emerald, which says that those pendente lite cases, and I'm quoting from the case now, they don't represent a determination that a subsequent purchaser lacks standing to contest practically anything a plaintiff might assert. That case actually said that the purchaser who intervened there had the ability to require the plaintiff to prove the prima facie elements of its case. And that's what I would argue we're trying to make the plaintiff do here too. We're saying there's no scenario in which you could ever state a claim here, because this statute, and it's very clear in unambiguous terms, says that that lien terminated. And it doesn't matter if they made part payments. It doesn't matter if they have a modification agreement. If it wasn't recorded, it doesn't comply with the statute. And I know I've gone over time, so I will conclude by asking the court to reverse the final judgment unless the court has any other questions.
Okay.
Thank
Very
you.
much. Again, thanks both counsel for your preparation and your argument. Really do appreciate it. That'll conclude this session of the oral argument. You all enjoy the rest of your day.